Hey there. Today I want to tell you about a new law that is slowly making its way through Parliament in Ottawa. It's a private member's bill, Bill C-316, and basically it's how the Trudeau government is planning to use your money to sue itself. I know it makes no sense, but it's actually been happening for years. The big change that this new law is proposing is to make this crazy program, which is called the Court Challenges Program, permanent. I can't wait to tell you all about it. If you're new here, welcome. My name is Christine and I'm the litigation director with the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing legal cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember that nothing in my videos is ever legal advice. If you have your own legal question or problem, consult your own lawyer. Okay, so let me tell you about this new private members bill, Bill C-316. It relates to something, as I said, called the Court Challenges Program. Now, the Court Challenges Program offers federal taxpayer money to certain charter challenges, legal challenges based on the Charter of Rights and Freedoms. And the program is essentially the federal government handing taxpayer money to lawyers and activists to then sue the government. The program's been around for years, but what C-316 would change is that it would embed this controversial court challenges program directly into legislation. To me, this is completely crazy. The government should not fund lawsuits against its own laws with taxpayer money. I mean, this should be very obvious. If the government is so concerned that their own laws are unconstitutional, they should repeal them. And if they think that their laws are fine, they should respond to legal challenges that are brought by others, not by paying to sue themselves. That just makes no sense. And it's enraging that the government is using our money, our taxpayer money, to do this. Now, as I said, the Court Challenges Program isn't new. It's been around for a while, and it's been called a political football by the Canadian Bar Association. It's been punted back and forth by successive Liberal and Conservative governments. And the origins of the program are actually pretty strange. There's this mythology or lore around how it started, that the claim is that it was started in the 1970s to defend language rights of minority groups in Canada. And I guess like every good story, this is partly true, but there is, of course, more to it. What really happened is that the government of Pierre Elliott Trudeau created the Court Challenges Program in 1978 as a way of indirectly attacking Quebec's Bill 101. This is a French language law. For Trudeau Sr. to attack Bill 1 directly as a Montreal-based politician who was dependent on the Quebec vote, that would have been an obviously politically dangerous thing for him to do. So he didn't want to challenge Bill 101 directly or use the federal disallowance power to stop it. So he came up with the Court Challenges Program so that he could give third parties who were independent of government taxpayer money to do indirectly what he didn't want to do directly. And this is important context when you hear people talk about the, allegedly altruistic origins of the program. It's important to remember that it was a political decision by the senior Trudeau government of the 1970s to use federal tax dollars to indirectly attack the choices by provincial governments in order to save their own political face. But the program was then sort of tossed back and forth following the election of Brian Mulroney. He initially expanded the program in 1985, and then he withdrew it in 1992. It was then reinstated by the Liberal Prime Minister Jean Chrétien in 1994, and then abolished by the Conservative Prime Minister Stephen Harper in 2006. And of course, it's now been reinstated by Liberal Prime Minister Justin Trudeau. Now, when the program was scrapped by Stephen Harper, John Baird, who was at the time the president of the Treasury Board, who's kind of in charge of the money, he argued that it doesn't make sense for the government to pay people to fight its own laws in court. And I think indeed this is exactly how I feel about it. Bill C-316, which is now making its way through Parliament, as I said, what it would do is entrench the court challenges program into the Canadian Heritage Act, and this would make it harder for future governments who want to repeal the program to do so. It would no longer just be a program at the discretion of the political leadership. They would actually need to change legislation if they want to get rid of it, sort of to try and put an end to this political football. But I think it's putting an end to it by making it permanent when really the solution should be to eliminate this program entirely. So Bill C-316, I think, would be a big mistake, and I'll tell you why. The government can't hold itself to account by funding litigation against its own policies and laws. Funding for a program like this is going to be inherently and inevitably politically skewed by the partisanship of the government in power. We actually don't even have information about which cases are funded. That is no longer disclosed until all the litigation is completely concluded. So there's no transparency about the political or partisan tilt of cases that do or don't get funding. But we do know about old cases that were funded. And there's some pretty crazy examples. For example, the landmark freedom of expression case, Harper and Canada, which was a challenge to federal election advertising spending limits by third parties. This was a lawsuit that was brought by a nonprofit organization called the National Citizens Coalition. We know that that challenge, the National Citizens Coalition part of it, even though it was a challenge, a charter challenge, it wasn't funded. But two other organizations, Democracy Watch and the National Anti-Poverty Organization, they did receive funding in order to intervene in support of the government's own laws. That completely goes against the notion of funding charter challenges. This is actually funding upholding the government's laws. Another big problem is that we know that the Minister of Heritage is the one who appoints those expert panels who decide whether or not a particular case will get taxpayer funding. And the politics of the expert panel really appears to be drawn from one side of the political spectrum, and I would say that it is to the left of progressives. The panel includes an academic progressive from Toronto Metropolitan University, TMU, formerly Ryerson, and his Twitter feed right now is just a fire hose of anti-Israel propaganda. Another panel member uses she, her, and they, them pronouns, and is a director at an organization which describes itself as supporting Black, queer, and trans women, femmes, and gender expansive folks. So obviously people are entitled to their own politics, their own perspectives, their own opinions. But I do have to say that the views of these expert panels who are selecting which charter legal challenges will get funding is decidedly one note. There are not any legal conservative thinkers on these panels. It seems to be far left thinkers only. So when you think about the people who make up these panels, can we realistically expect that the court challenges program would fund a charter challenge to the federal government's, for example, Online Harms Act? This is a law that is a kind of censorship. It has obvious constitutional problems, which I've talked about at length on this channel. For example, the creation of a standalone hate speech offense with a potential maximum of life imprisonment, as well as the creation of peace bonds for future speech. So the court challenges program promises to fund test cases about freedom of expression. Do we think it would fund a charter challenge to the Online Harms Act based on the politics of the people who make up that panel? I think that's very unlikely. Now, while the lack of transparency means we actually won't know if a challenge to the Online Harms Act would ultimately be funded, it just seems reasonable to me that it would not be funded. This is not the type of issue that the people who make up the decision-making body for this program are interested in funding. This is a problem that is really inherent in the structure of the program. Now, as my friend Professor Ian Brody has pointed out in his criticism of Bill C-316 at Heritage Committee, once government decides which groups should get funding to launch court cases, rights litigation ceases to be a grassroots, ground-up process of holding government to account. Now, in any event, there actually just isn't a need for a court challenges program diverting the scarce tax dollars that we all pay to activist lawyers. There are civil society groups like the Canadian Constitution Foundation that already provide an extremely effective and unbiased check on government. Now, as you all know, one of the most important pieces of constitutional litigation in the last decade has been our judicial review of the Trudeau government's invocation of the Emergencies Act, which found that that invocation was illegal and unconstitutional. Now, that was a novel case brought by us at the CCF, and we received no funding from the court challenges program to achieve this result. And we've also successfully challenged all kinds of other government laws, like portions of the Federal Elections Act that violated the right to freedom of expression, again, without taxpayer funding. We've been involved in challenges to municipal laws that restrict protests, again, without funding from the court challenges program. And this is the case with many other successful charter challenges. Really, the largest impediment to civil society groups holding government to account is the government itself. It's delays within the judicial system, which have been exacerbated and made worse by the government failing to fund judicial resources, failing to appoint judges. And this is a problem that the government could and should address that would do a lot more to improve access to justice than the controversial and partisan selection of specific lawsuits. So what do you think of the court challenges program and about Bill C-316? Do you think that this program needs to be scrapped? Do you think it's an important accountability measure? And if you think that, please explain why, because I completely disagree. I think this is a huge waste of our money. Now, my colleague Josh DeHaas actually spoke at the Heritage Committee a few weeks ago opposing this private member's bill and explaining some of the problems with it. I have a video of his submissions, which I'll link to above and I'll also link to below, so you can click on and watch that. Now, if you want to get updates about this law as it progresses, you can sign up for our email freedom updates at theccf.ca/freedom updates, or you can subscribe to this channel. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.